Resuming debate, the honourable member for Beaches East York.
Thank you very much, Mr. Speaker. I'm pleased to rise today to speak to Bill C-51 at third reading. Of course, there was only ever one proper way to dispose of this bill, and that was some time ago in the legislative process at second reading, and as per the reasoned amendment put forward by my NDP colleague, the member for Esquimalt-Wandafuca, which suggests that we decline to give second reading to the bill. I was pleased actually this morning to second another such reasoned amendment, which was in effect to throw the bill out so that we didn't discuss this and this bill never became law. I do want to take a moment, Mr. Speaker, to thank the member from Esquimalt-Wandafuca and the member from Alfred Pelin for leading our caucus's vigorous opposition to this bill, because this bill, Mr. Speaker, is a bill unworthy of any Canadian government to lay before this House, as this Conservative government has done. Certainly it is a bill unworthy of any opposition support, as the Liberals have done. It is so because what is rotten about this bill, Mr. Speaker, lies at its very heart, with the bill's premise that it is only by way of sacrificing the rights and freedoms of Canadians that we are able to make Canadians safe. I've listened carefully to Conservatives try to rationalize this premise. I've listened carefully to Liberals try to rationalize this premise, Mr. Speaker, and they can't. They compensate with hyperbole, with an extremism in their language, all of their own. Liberals, the self-proclaimed party of the Charter, are the Conservatives' allies in this. Afraid of what the Conservatives might do to them if they disagree, they've turned on the Charter and have agreed to support a bill in which our rights aren't rights anymore. Because if we considered them so, goes the logic of the bill and of the Conservatives and Liberals who support it, we couldn't be safe here in Canada. This is what it's come to, Mr. Speaker. Their consent to a bill that gives to the Canadian Security Intelligence Service, CSIS, new radically altered authorities. CSIS, Mr. Speaker, was originally charged with a broad mandate but limited powers, certainly no so-called kinetic powers to disrupt, no powers to arrest, or in the terms of Forsese and Roach, to do things to people in the physical world. This is not only no longer the case, Mr. Speaker, but through this bill, CSIS is provided with such kinetic powers with little constraint, restricted only from committing bodily harm, obstructing justice, and violating a person's sexual integrity. The provisions of C-51 provide to CSIS the authority to take measures, both at home and abroad, to disrupt threats when it has, quote, reasonable grounds to believe that there is a threat to the security of Canada. Activities to disrupt threats are not to contravene a right or freedom guaranteed under the Charter unless authorized by a warrant under the Act. But, and here, Mr. Speaker, the bill turns the idea of judicial warrants on its head. In the normal course, judicial warrants are designed to ensure the preservation or integrity of Charter rights, specifically to protect against unreasonable searches and seizures. The special warrant system laid out in C-51, Mr. Speaker, pre-authorizes the violation of absolute rights, such as, for example, the right to be free from cruel and unusual punishment. This, Mr. Speaker, represents a departure from our constitutional tradition in Canada and the role of the judiciary in that tradition. Section 1 of the Charter allows rights to be violated where such violation is considered, quote, reasonable in a free and democratic society, but only when prescribed by law, which usually means specified by statute, which is something determined democratically here in this House, in Parliament, which depends in turn on some rigorous legal justification. This tradition does not permit a judge to make a new exception to a Charter right, but this bill does, or at least seeks to. Now, Mr. Speaker, let me heap a few complications on top of this situation. Firstly, the bill does not provide for any oversight of CSIS's own determinations of whether or not it ought to or needs to seek a special warrant. The bill leaves such decisions to CSIS absent any check or scrutiny of those decisions. It is only in the instance that something goes wrong or when its activities morph into criminal activities led by the RCMP, criminal investigations led by the RCMP, that such decisions may come under some scrutiny, potentially, Mr. Speaker, it's worth noting, threatening the prosecution of the case. But it is worth noting, too, Mr. Speaker, that where warrants are brought forward by CSIS seeking pre-authorization by the court of the violation of a charter right, such considerations are to be dealt with in secret. Forsese and Roach illustrate the problem by way of their comparison of the open and public discussion in the British Parliament of the validity of exclusion orders for British citizens who have joined ISIS or ISIL. Whatever one might think, Mr. Speaker, of those exclusion orders, the fact of that parliamentary debate stands in stark contrast to the provisions of this bill, which would have such discussions take place with only a judge and the government side present, and in the absence of any person or representative body to argue against the charter breach. Now, perhaps, Mr. Speaker, a system of special advocates and advocacy will emerge or be adopted by the courts, to be seen, I guess. But we are left, Mr. Speaker, most certainly, inevitably, under this bill, with the decisions of the judiciary to deny or permit violations of the absolute rights of Canadians being made in secret and being kept secret, far from the scrutiny of, well, anybody, Mr. Speaker. Another problem, Mr. Speaker, the matters before the judiciary under this special warrant system are not restricted to matters of terrorism. It is a far broader scope of matters and conduct that fall subject to this system. Terrorism is only one such form of activity that falls under broadly defined security concerns of the bill. So does interference with critical infrastructure, and so does interference with the capability of the government in relation to, for example, the economic or financial stability of Canada. This broad language, potentially at least, brings First Nations most obviously, but also any civil society group making territorial claims in response to development projects such as mining or other extractive activities into the ambit of this bill and subject to the special disruption activities of CSIS and the special warrant process of the courts. This broad language, again, potentially at least, brings any civil society group, environmental groups, for example, that conservative ministers have been known to refer to as eco-terrorists, engaged in civil disobedience activities with respect to energy infrastructure, for example, into the ambit of this bill and subject to the special disruptive activities of CSIS and special warrant processes of the courts. Mr. Speaker, none of this, none of what I have said today is to deny the very real threat of terrorism to the safety and security of Canadians. How can we? From 9/11 onwards, at least, we have recognized the threat, our vulnerability, and the need to respond to protect ourselves. And whatever that hate is that moves ISIL to do what it does, we cannot but acknowledge that it has inspired some Canadians to leave here to join them, and it has inspired at least a couple of Canadians to turn that hate on their own here at home. We cannot forget Corporal Cirillo and Warrant Officer Patrice Vincent. We cannot forget October 22nd, when all of us in this place wondered for at least a moment if that was to be our last moment. But the impossibility of supporting C-51 was captured most simply and elegantly by the leader of the official opposition when he said, quote, "We cannot protect our freedoms by sacrificing our freedoms." Our challenge, Mr. Speaker, is not to forsake who we are and what we believe in when we are afraid, when we are tested. Our challenge is to ensure that Canadians are safe and secure in Canada, in a Canada that protects their rights and freedoms. That vision of Canada is the New Democrats' vision of Canada. It is different from the Conservative vision represented by C-51. It is different from the Liberal vision represented by their fear of not supporting C-51, by their fear of Conservatives. And so it is the only vision offered here today in this House that is consistent with the long, proud history of this country and the only vision that will ensure that we have a long, proud future. Thank you, Mr. Speaker.
Questions and comments? The Honourable Parliamentary Secretary for Public Safety.